All right. Well, we'll get started. Thanks everybody for joining us today. My name is Meghan de Pinto-Smith and I'm a Senior Associate in the McKays Solicitors Employment and Industrial Relations Law team. I also have Tamara Hage here with me, who's an associate in our team.
Hi, everyone.
So we're here today to talk you through some of the significant changes happening in the employment and industrial relations law space. And these are some of the biggest and significant changes we've seen since the introduction of the Fair Work Act in 2009. So it's really important to get across what's changing and what your business needs to do to ensure you're complying with the changes. Some of the changes have already come into effect and more are coming or proposed to be coming. And a warning, there are a lot. We could actually talk for days about the changes, given there are so many and there is so much detail. But for the purposes of today, we're going to give you a quick summary of some of the key changes we've found relevant to our clients. And then you can take that away, process it, and seek any further advice you need from us. Now, we've listed on the slide the topics that we'll cover today, starting with the Closing Loopholes Bill, which a lot of you may have heard about recently in the news. As you can see, there are a lot of topics we'll cover, so please feel free to email us if you have any questions. Our contact details will be set out on a slide at the end of the session, so you can send any questions through to us that you have. Okay. So the Fair Work Legislation Amendment Closing Loopholes Bill 2023 was early last month introduced into Parliament. The aim of this bill is to close loopholes that undermine pay and conditions and improve work health and safety laws. So they're proposing a number of key changes, which I'll talk through, and you can follow on the slide to try and achieve those goals. Just keep in mind the bill is complex. It runs at nearly 300 pages. So as I mentioned, this is just a brief summary today of the key changes, but you can access the bill on the Parliament of Australia website if you are interested in reading further, and we're always here if you need further advice. So starting with the definition of employee and employer. Now, the bill introduces what they call an interpretive principle for determining the ordinary meaning of employee and employer. And that assessment requires looking at the real substance, practical reality, and true nature of the working relationship by considering the totality of the relationship rather than just the terms of any written contract. And what this change aims to do is it's aiming to undo recent decisions made by the High Court, like in the case of personnel contracting and JAMSEC, which have been talked about prominently recently, which have held that the question of whether a relationship is one of employment should be answered only by reference to the terms of the contract in most cases. So there's a move away from that train or rule. The next change that's happening is the existing definition of casual employee is proposed to be replaced. So what that will mean is that under the new definition, an employee is considered a casual employee if the employment relationship is characterised by an absence of a firm advance commitment to continuing an indefinite work, and the employee is paid a casual loading or a specific rate of pay for casual employees under an industrial instrument or the terms and conditions of their employment contract. And there'll be factors used to help determine whether someone is a casual or not, including whether there's a regular pattern of work. Casual conversion changes are also happening. So the bill introduces a new employee choice pathway for eligible casual employees to change to permanent employment if they want to. And they can do this by issuing a written notification to their employer, and there'll be steps involved with employers having to respond to that. There's also a new criminal offence for wage theft being introduced, and that applies to intentional conduct. And the penalties for such an offence include potential prison terms and maximum fines of up to 1.5 million for an individual, 7.8 million for a body corporate, or 3 times the value of the wage underpayment. And as part of that, we'll also see an increase in civil penalties as a result of the bill, which will be 5 times the current penalty. In regards to family and domestic violence, the bill improves protections against discrimination for workers who are subjected to family and domestic violence. And they do that by introducing a new protected attribute to the Fair Work Act. So what that means is that you can't terminate someone because of them being subject to family and domestic violence, and a term can't be included in a modern award or an enterprise agreement which discriminates against an employee on that basis. In regards to sham contracting, the bill proposes to change the defence to misrepresenting employment as an independent contractor arrangement, which is what they call sham contracting. So they changed that defence test from a test of recklessness to one of reasonableness. So what that means is that an employer will not be held liable for sham contracting if at the time of the misrepresentation, the employer reasonably believed that the employee was an independent contractor. Labour hire is another big significant change which is proposed to happen. So the changes they're implementing or considering implementing are aimed at protecting bargained wages in enterprise agreements from being undercut through the use of labour hire workers who are paid less. So the changes mean that the Fair Work Commission will have the power to make orders to ensure that labour hire workers are paid the same rate as those in the host employer's enterprise agreement. And that excludes specialist or expert services, and there's a 3-month default exemption for surge work and temporary replacement. And there's also other exemptions, including where the host is a small business employer. Another big change is the introduction of an employee-like category, and that's introduced for certain digital platform gig workers, which haven't previously had conditions. So the bill will allow the Fair Work Commission to set fair minimum standards, including minimum pay for employee-like workers, and it will also protect those workers from being unfairly deactivated or removed from a platform, with the Fair Work Commission being able to weigh in on those matters. But the Fair Work Commission can't weigh in on matters such as rosters and overtime. A similar change is happening in the road transport industry, where the Fair Work Commission will also be allowed to set minimum fair standards to ensure that the road transport industry is a safe, sustainable and viable workforce. In terms of unfair contracts, the Fair Work Commission will be able to deal with disputes about unfair terms in services contracts where an independent contractor is a party. There's also changes in regards to compliance notices. So Fair Work Ombudsman compliance notices can require an employer to actually calculate an underpayment owing to an employee, and a court can order the person who receives the notice to comply with that notice, which wasn't previously available. There's further changes to enterprise bargaining and some existing changes which I'll talk about later in the session. But the bill makes a few changes in that it allows a franchisee of a common franchisor, or a number of them, to voluntarily bargain together for a single enterprise agreement. It also allows supported bargaining and single interest employer agreements to be replaced by single enterprise agreements at any time where conditions are met. And there's also an ability for the Fair Work Commission to make and vary enterprise agreement model terms regarding flexibility, consultation, and dispute resolution. A few more changes to get through. Now, union delegate rights are also changing. So the bill offers a framework for union delegate rights so that there's more protections for them in terms of them seeking to exercise those rights. There's also a Commonwealth industrial manslaughter offence being introduced, where the penalties are 18 million for bodies corporate and up to 25 years imprisonment for individuals. In regards to federal OHS laws, the bill increases maximum penalties, for example, for Category 1 offences involving reckless or criminally negligent breaches of duty. So this will increase penalties to 15 million for a body corporate and 1.5 million or 3 million for an individual who commits an offence as a person conducting a business or undertaking or an officer. And there's also an increase to 15 years of maximum imprisonment, which is up from 5 years previously. In regards to rights of entry to investigate underpayment, the bill enhances the ability of people with a permit to enter a workplace to investigate suspected underpayment, so something to watch out for. There's also a carve-out to the small business redundancy exemption. Now, that exempted small businesses with fewer than 15 employees from providing employees with redundancy pay under the National Employment Standards. So what this carve-out does is that it is for employers who are not initially a small business employer, but they gradually become one during a bankruptcy or liquidation process. So this will mean that employees terminated due to their employer's insolvency retain their entitlement to redundancy pay if their employer was not a small business prior to the insolvency. The bill provides support for first responders as well, particularly those diagnosed with PTSD, by introducing a presumption that their employment significantly contributed to them sustaining PTSD for the purpose of a workers' compensation claim. And finally, the Asbestos Safety and Eradication Agency will have expanded functions so that they can address silica-related diseases, which is also a significant change. So lots of changes proposed. You may have heard that there are many parties, particularly employer groups, who are raising concerns about the bill, particularly about its complexity, its uncertainty, and the costs which will be associated with these changes. There'll certainly be a lot of submissions made by parties against the bill or parts of it, and possibly amendments made before the bill is passed. So all of these changes we've just spoken about, they're all proposed and likely to come into effect, but there could be some amendments and changes based on what other parties submit against the bill proposed. So we'll keep you up to date across our LinkedIn page and our emails and future events we have, so that you can keep across how the bill develops. But in the meantime, it's important to just be wary of the significant implications of these changes and start to take steps to prepare for if these changes happen, so that you've got a plan in place as to what you'll do. Now, the next topic I'll talk about is in regards to psychosocial hazards in the workplace. Queensland recently published a new work health and safety code of practice called the Managing the Risk of Psychosocial Hazards at Work. And what that does is it requires workplaces to eliminate or minimise psychosocial risk as far as is reasonably practicable. And that code's been in effect since the 1st of April this year. And a question we often get asked is, what are psychosocial hazards? So they are anything in the design or management of work that increases the risk of psychological or physical harm. So you can see on the slide there a few examples listed. So they can include job demands, low job control, poor support, bullying, harassment, and the other examples set out on the slide there. What the code does is it gives practical guidance on how psychosocial hazards and risks can be managed or controlled, and it can be used to help determine what is reasonably practicable to reduce psychosocial risk. And one thing to note is that the code applies to all work and workplaces covered by the Work Health and Safety Act, but it doesn't apply to some Queensland workplaces in the mining and resources industries and Commonwealth government departments and Australian public service agencies. The big question is, what should businesses be doing to ensure compliance? And the code has a suggested risk management process involving 4 steps, which are set out in the diagram on the slide. And step 1 is to identify any psychosocial hazard. So that means consulting with workers and health and safety representatives, if there are any, to identify hazards that could lead to psychosocial risks. Step 2 is to assess the risk. So that means assessing the risk the psychosocial hazard poses and deciding how to control it. Step 3 is to implement controls to manage the risk. So that means putting in place measures that either remove or reduce hazards as effectively as possible. And there are 3 possible levels of control. The first is to remove the risk completely and eliminate the hazard. The second level is to eliminate as many of the risks associated with the hazard as possible. So that could be, for example, isolating the hazard from workers or replacing the hazard with a safer alternative. And the third level is relying on human behaviour and supervision to control the risk. But that's considered the least effective way to reduce risk. Then the final step is to monitor and review the controls. So that means maintaining and reviewing the control measures regularly to ensure they remain effective over time. And keep in mind that the controls will differ depending on the type of organisation and the nature of the work being undertaken. And an important thing to remember is that all steps must be supported by consultation, which you can see in the outer rim of the diagram. So you've got to consult with your workers at each step. One thing that we suggest is that you keep records of the risk management process, as this will help to demonstrate what's been done to meet your obligations if there's ever any dispute about you not having complied with your obligations. And if there is non-compliance, enforcement action can be taken. So employers, if they haven't already, should really be conducting a risk management process using the guidance of the code to ensure the psychosocial safety of their workers and to reduce the risk that any action will be taken against them for non-compliance. All right, the next topic I'll talk about is sexual harassment. What's happened is that since 6th of March this year, sexual harassment in connection with work, including in the workplace, has been expressly prohibited under the Fair Work Act. And a person or a company can be held vicariously liable for sexual harassment by either an employee or an agent in connection with work, unless they can prove that they've taken all reasonable steps to prevent the conduct. And there's the ability for multiple aggrieved parties, like employees and unions, to make an application to the Fair Work Commission for a Stop Sexual Harassment order, which is in addition to their existing options to pursue legal action based on existing laws under the Sex Discrimination Act and other state and territory legislation. Another significant change is that since the 13th of December 2022, there's been a positive duty on employers to take reasonable and proportionate measures to eliminate sex discrimination, including sexual harassment in the workplace. So that means employers are required to shift their focus from actively preventing workplace sexual harassment rather than just responding only after it occurs. So they have to be proactive to avoid sexual harassment occurring. Now, there's another diagram which sets out 7 standards that the Australian Human Rights Commission expects organisations and businesses to do to satisfy this positive duty. So I'll work through each of them briefly. The first standard is leadership. So that requires senior leaders to understand their obligations and have up-to-date knowledge about relevant conduct. They also have to ensure appropriate measures are developed, recorded in writing, communicated and implemented to prevent and respond to unlawful conduct. They are expected to review the effectiveness of measures and update workers on that review. And they are meant to be visible in committing to safe, respectful and inclusive workplaces that value diversity and gender equality. The second standard is culture. So similarly to what we've just discussed, organisations and businesses have to create a culture that's safe, respectful, inclusive, values diversity and gender equality. And it has to empower workers to report unlawful conduct and minimise harm and hold people accountable. The third standard is knowledge. So organisations and businesses are recommended to develop, communicate and implement a policy regarding respectful behaviour and unlawful conduct. And they should be supporting workers to engage in safe, respectful and inclusive behaviour through education, including on expected standards of behaviour. The fourth standard is risk management. So organisations and businesses are expected to recognise that unlawful conduct is an equality risk and a health and safety risk. and they must take a risk-based approach towards prevention and response. Standard 5 is support. So appropriate support must be made available to workers who experience or witness unlawful conduct, and they must be informed of that support. Standard 6 is reporting and response. So there has to be appropriate options for reporting and responding to unlawful conduct, and they have to be regularly communicated. Responses should be consistent, timely, and they should minimise harm and victimisation. And consequences that are imposed should be consistent and proportionate when you're looking at imposing consequences. And the final standard, standard 7, is monitoring, evaluation and transparency. And what that requires is that there be appropriate data collected to understand the extent and nature of unlawful conduct concerning the workplace. That data should then be used to improve workplace culture and develop measures for preventing and responding to unlawful conduct. And businesses and organisations should be transparent about reported behaviours and actions taken. So they're the 7 standards that all businesses and organisations should be complying with to satisfy this positive duty that's in law now. And now I'll hand you over to Tam so that she can talk you through some of the other changes that are happening.
Thanks, Megan. Hi, everyone. Tamara, hopefully you're still with us all. I know that there's an overwhelming volume of information, to digest here. So I'll be moving on to pay secrecy. So as you may be aware, since 7th of December last year, employees have now actually had a workplace right to share information regarding their pay and other terms and conditions which are needed to work out their pay, and to also ask other employees about their pay and employment terms and conditions. So what this means now for employers is they can't actually take any adverse action against an employee if they exercise these workplace rights. So if you have any employees who have entered into employment contracts which contain a pay secrecy clause before the 7th of December last year, then this protection applies from the time that that contract is actually amended. Pay secrecy terms otherwise included in contracts entered into or after the 7th of December of last year have no effect and cannot be enforced. And in fact, then from 7th of June this year, it's now law that a pay secrecy term cannot be included in a contract at all. So in terms of what you need to be doing as an employer now in relation to these changes is obviously reviewing your current employment contracts, but also your policies and procedures to ensure that they don't prevent employees discussing their pay, and also be aware now that employees have that workplace right to be talking about their pay and asking other employees about their pay, and you can't unfortunately take any adverse action against them for doing that. So moving on to fixed and maximum term contracts, this has been another quite topical issue or change across many industries, and a lot of clients have been coming to us for advice on this topic. So from 6th of December this year, employers can't enter into a fixed term or maximum term contract in a number of circumstances, including where firstly the term exceeds 2 years, and this includes any extensions or renewal periods. where the contract contains any right to extend or renew the contract more than once. And this is even if the total term of that contract would not exceed that 2-year limit, or where the employee has previously been engaged on 2 consecutive contracts for the same or substantially similar work. There are some very limited exceptions to these circumstances, and there will also be anti-avoidance provisions to prevent employers from avoiding these new rules. There will also be, importantly, a new fixed-term employee information statement. So similar to the current Fair Work Information Statement and the statement, which must be, like the others, provided to an employee who is entering into a fixed-term contract before they commence or as soon as practicable thereafter. Again, in terms of what you need to be doing, you should be reviewing current employment arrangements and thinking about if you rely on fixed or maximum term workforces currently, and planning ahead to structure your workforce to ensure that you comply with these new laws. You should be conducting an audit of employees of current employees, I should say, on fixed and maximum term contracts to work out how long they've been currently employed under those arrangements, including previous contracts. And you should be generally reviewing your current fixed to maximum term contracts to be removing any clauses that, for example, provide the option to extend or renew any current term. Okay, flexible working arrangements. So we had some changes take effect on 6th of June this year regarding flexible working arrangements. So as a result of those changes, we have more employees now who are able to make a flexible working arrangement request. And those employees are employees who are pregnant and employees or a member of their immediate family or household who are experiencing family and domestic violence. Another pretty important change is that employers now have a positive obligation to discuss a request with an employee and genuinely try to reach an agreement and have regard to the consequences that would arise as a result of refusing such request by an employee. In terms of process, employers must, within 21 days of receiving a request, either approve the request or have discussed and agreed with the employee on changes to the employee's requested work arrangement, or have discussed the proposed arrangement with the employee and set out the reasonable business grounds on which they refuse to grant the request. Reasonable business grounds, we usually get the question, what are they? So those might include when the request is too costly for the employer to implement, when there is no capacity to change the working arrangements at all, when the changes would be impracticable by requiring changes to the work arrangements of existing employees or even hiring new employees, when the change would likely result in significant loss in efficiency or productivity in the business, and when the changes would likely have a significant negative impact on customer service. So those are the examples of the grounds which a business may rely upon. However, as I've just run through, we now have that positive obligation on employers to genuinely try to reach an agreement with an employee. Remember, as under the previous laws in this area, any response by an employer must be in writing to the employee. So remember that point. In terms of what employers need to be doing, they should be, again, reviewing their current policies and procedures to ensure they meet their obligations in relation to responding to these requests for flexible working arrangements by employees. Okay, parental leave. Now, we've had quite a few changes in this area to both unpaid and paid parental leave. So firstly, just running through some changes in relation to requests for extending unpaid parental leave. So we had some changes take effect on the 6th of June in relation to how employers must respond to requests to extend unpaid parental leave. So similar to those changes we just discussed in relation to flexible working arrangement requests, an employer is required to respond to a request within 21 days, discuss that request with the employee, and then make that genuine attempt to reach an agreement. So you can see there's a common theme here. Again, in the event of a refusal, an employer must explain the reasonable business grounds for the refusal, like we've just discussed in relation to flexible working arrangements, set out what period of extension could be granted, if any, and also explain the employee's right to challenge that refusal. Again, employers should be reviewing their current policies and procedures to ensure they meet their obligations in relation to responding to these requests for extending unpaid parental leave. On the 1st of July this year, we had some changes regarding flexible unpaid parental leave. So just to run through these briefly, again, today we don't have a lot of time and there's quite a lot of detail in some of these changes, but we just want to flag as much as possible for you what you need to be mindful of moving forward. So these changes deal with allowing working parents to take up to 100 days of their 12-month leave entitlement flexibly. This is an increase from the previous 30-day entitlement. Allowing employees more choice about when they can take flexible unpaid parental leave, removing restrictions which previously stopped employees taking more than 8 weeks of unpaid parental leave at the same time as their spouse or de facto partner, which was known as concurrent leave, and ensuring both parents can take up to 12 months of unpaid parental leave, regardless of the amount of leave that the other one takes. They can also both apply for an extension of up to 12 months without impacting the amount of leave available to the other parent. So quite a few changes there. Paid parental leave. So we've had some changes. The changes I've just run through, they actually align with some updates we've also had with the paid parental leave scheme, including that partnered couples can now claim up to 20 weeks of paid parental leave between them. Parents who are single at the time of their claim can access those full 20 weeks alone. And the former dad and partner pay entitlement has now been removed, and the additional 2 weeks pay has now been combined with the existing 18 weeks parental leave pay to make up the 20 weeks. These changes affect employees whose baby is born or placed in their care on or after the 1st of July. Some other changes we've had in the paid parental leave space, allowing partnered employees to claim a maximum of 20 weeks pay between them, with each partner taking at least 2 weeks, except in some other circumstances, introducing a $350,000 family income limit, which is indexed annually from the 1st of July 2024 for claiming paid parental leave pay. Expanding the eligibility rules for fathers or partners to claim paid parental leave pay, making the whole payment flexible so that eligible employees can claim it in multiple blocks until the child turns 2, and removing the requirement to return to work to be eligible for the entitlement. There are also some proposed changes which you may have heard about to increase that total parental leave pay available to families to 26 weeks by 2026. So a lot of changes in that space, and apologies that we have to move through them so quickly today. Moving on to paid family and domestic violence leave. This is another topic that we've been been fielding quite a few queries from clients in relation to. So as hopefully you're aware, since the 1st of February 2023, employees of non-small business employers, and that includes part-time and casual employees, they've been able to access 10 days of paid family and domestic violence leave in a 12-month period. Since the 1st of August 2023, so there was a 6-month grace period. Employees of small business employers, so those with less than 15 employees, have been able to access the paid family and domestic violence leave. Now, employees can take this leave if they need to do something to deal with the impact of family and domestic violence. So, for example, this might include making arrangements for their safety or the safety of a close relative of theirs. That might include relocation, for example, attending court hearings, or accessing police services. There are some rules about how information in relation to paid family and domestic violence leave must be reported on pay slips. So this is a pretty big one, and what information must not be included, obviously in an effort to reduce risk to that particular employee and their safety. So while employers need to be obviously keeping a record of any leave that is taken and leave balances, pay slips must not expressly mention that the employee is taking family and domestic violence leave. So the question we're getting from a lot of employers is, how do you record this on the employee's pay slip? It needs to be recorded as either ordinary hours of work or another kind of payment for performing work. So that might be an allowance, bonus, or overtime. But something to remember is, if an employee requests it, you can actually record the time taken as another type of leave on their pay slip. So, for example, annual leave. Other things that you should be doing as an employer as a result of these changes, again, checking employment documentation, ensuring that your policies and procedures are consistent with the changes in this area so that you can ensure that you're complying. Okay, anti-discrimination. So since 7th of December last year, breastfeeding, gender identity, and intersex status and employees subjected to family and domestic violence leave will now be new protected attributes under the anti-discrimination provisions in the Fair Work Act. What this means is employers are prohibited from taking adverse action, such as termination, against current or future employees because of any of these attributes. Just recently, Workplace Relations Minister Tony Burke has also revealed that employees subjected to family and domestic violence will have new protections against workplace discrimination. This change will prohibit employers, again, from taking adverse action against such employees by making this as a protected attribute under Section 351 of the Fair Work Act, which deals with discrimination, as I've just outlined at the beginning there. The Act is also proposed to be amended to make it illegal to have any term of an enterprise agreement or a modern award that discriminates against family and domestic violence victim survivors. So again, I sound like a broken record, but employers should be reviewing their employment documentation, such as their policies and procedures, and obviously any training that is given to employees in this space in relation to anti-discrimination, to ensure that people are aware of these new protected attributes. Okay, so we've got some key employment figures which changed on the 1st of July this year, which you're probably already aware of, but we will just run through them for completeness today. So this includes our national minimum wage, which increased to $882.80 per week, or $23.23 per hour. This flowed through as a 5.75% to our minimum rates under modern awards. The superannuation guarantee rate increased from 10.5% to 11%, and that is going to continue increasing by 0.5% on 1st of July each year until it reaches 12% in 2025. And we also had our high income threshold increase from $162,000 to $167,500 per annum. Now, that last point, this is relevant to employees who obviously earn above the high income threshold being ineligible to bring an unfair dismissal claim unless a modern award or enterprise agreement applies to them. And they can also be excluded, of course, from modern award coverage if there is a guarantee of annual earnings provided by the employer to pay the employee an amount of earnings no less than that high income threshold. So just to clarify the significance of that last point there. Getting through the changes. So we now move into some new protections for migrant workers. So on the 1st of July this year, there's been a new provision inserted into the Fair Work Act to deal with the interaction between that Act and the Migration Act. So this basically means that migrant workers continue to have the same rights and entitlements under workplace laws as other employees working in Australia, regardless of their migration status under the Migration Act. And importantly, a breach of the Migration Act will not affect the validity of an employment contract or a contract for services for the purposes of the Fair Work Act. Now, this includes in circumstances where the migrant worker has breached a condition of their visa, they do not have work rights, or they do not have the right to be in Australia. Employee authorised deductions. So looking ahead, from the 30th of December this year, employees will be allowed to authorise their employer to make salary deductions that are recurring and for amounts that vary from time to time. Currently, the law says that a new written authorisation between an employee and an employer has to be made if a deduction amount changes. But as always, you should be careful before you go deducting anything because of the rules under the Fair Work Act in relation to what is a permitted deduction. For example, it has to be principally for the employee's benefit and in writing. And there's obviously certain requirements around that. And if you're, not careful, then a particular deduction may in fact be unlawful. So it's always best to obtain legal advice in that regard. Superannuation. So from the 1st of January next year, so 2024, a right to superannuation contributions will actually be included in the National Employment Standards, so in the NES under the Fair Work Act. So what this is going to mean is that most employees who are covered by the Fair Work Act will actually have an enforceable right to superannuation where it's unpaid or underpaid. Currently, employees who are covered by a modern award or enterprise agreement that includes a requirement for superannuation contributions can apply to a court to enforce such a term. But these changes will obviously ensure that more employees have this right to bring this claim. So it just widens the scope of persons able to bring a claim. Okay, nearly there before I hand you back over to Meghan. So just lastly, we have also had some changes to the coal mining industry long service leave funding scheme. which are set to come into effect on the 1st of January next year. So this will obviously apply to any of the peoples joining us today from the mining industry. So these amendments have been proposed to ensure that casual employees are treated no less favourably than permanent employees in relation to these long service leave entitlements under the scheme. So they are ensuring that an employee's casual loading will be applied to levy payments by the employer into the fund, and the payment of the long service leave entitlement, which is ultimately made by the employer to the employee when they're claiming their entitlement. Additionally, there will be a change in the calculation method of the accrual of casual employees' long service leave entitlement, and the Coal Mining Industry Corporation will be required to publish the relevant levy reporting form publicly for employers to access. That will be published and available on the Federal Register of Legislation. I'll otherwise hand you back to Meghan to speak about enterprise agreements and bargaining.
So just some final changes I'll talk about. So there's some further changes being made to enterprise agreements and enterprise bargaining. So just as a quick summary, because I know we're running over time, on 7th of December last year, changes commenced making it easier for unions and employees to initiate bargaining. It's also now harder for employers to unilaterally terminate enterprise agreements which have passed their nominal expiry date. And there's an automatic sunset date or termination date of 7th of December 2023 for all agreements made before the commencement of the Fair Work Act that are still in operation, and they're called zombie agreements. So they'll all soon terminate. There's also some other changes, most of them commenced on 7th of June this year. What they are is that the Fair Work Commission has a greater power to intervene and resolve bargaining disputes where parties can't seem to reach an agreement. There's also an ability for employers with what they call clearly identifiable common interests to bargain together, or on application by a union be ordered to bargain together. The test for approval of enterprise agreements, which is known as the Better Off Overall or BOOT test, that's changing. So it required that employees be better off under the terms of the agreement than the terms in a relevant modern award. And that's all changing now. So rather than a line-by-line analysis, which that test required, now instead the Fair Work Commission will conduct a global assessment. There's also many of the prescriptive procedural requirements being relaxed. So the Fair Work Commission will conduct what they call a more broader genuinely agreed test. And the Fair Work Commission has published a statement of principles for employers on ensuring that employees have genuinely agreed to an enterprise agreement. So what should employers be doing now? If you have an enterprise agreement, you should review your current industrial relations strategy to take into account these changes. But even if you don't have an enterprise agreement, think about what the potential implications of these changes could be. For example, if you could be forced to bargain with other employers. So quite significant changes in that area as well. Now, that's all our topics covered. Thank you for listening to us today. I know there's been a lot of information we have given. There's a few pieces of legislation that we referred to on the slide there if you're interested in looking further. As I said in the first part of our session, feel free to email myself or Tamara if you have any questions or if there's anything further we can help you with. Our contact details are on this final slide. We're here to help employers navigate these changes, so please reach out if there's any way we can assist. And if you'd like to continue to keep up to date with employment and IR law matters, we plan to hold further sessions, and we're always posting articles and updates on our LinkedIn, on our McKays solicitors website, and also on our McKays employment and IR law LinkedIn page. So let us know if you'd like us to subscribe you to our updates. Send us an email, and you can always follow us on our LinkedIn page. We're always posting new updates about legislative changes or case updates and just general tips for employers on that page. So thank you all for joining us, and we look forward to seeing you at future sessions.
Thank you, everyone. Thank you so much.